Welcome. This is Professor Guerra Pujol from the University of Central Florida, and welcome to the Legal and Ethical Environment of Business. In this class, what I'd like to do is, or in this short video lecture, I'd like to introduce you to the main sources of law. And for that, what I've done is I've taken out my pocket constitution once again, because before we even jump into law, we have to understand something very important about the legal environment in the United States. And that is the following. The United States is a federal system. What this means is simply that we have two co-equal governments. The federal government, which we associate with our nation's capital, Washington, D.C., but also the state governments, now the 50 state governments. For example, here in Florida, the state government whose capital is in Tallahassee. And of course, there are 49 other states. What this means is that we're going to have, at a minimum, 51 sets of laws, right? We're going to have federal law and we're going to have state law. Now, oftentimes, this will pose very thorny issues. For example, which issues are delegated to the federal government and which issues belong to the states. As a general matter, we'll sidestep that. That can get very complex. The main idea is that according to Article 1, Section 8 of the Constitution, a number of powers are granted to Congress, such as the power to declare war or the power to regulate interstate and foreign commerce, the power to create a national post office system. All other powers, those powers not given to Congress, however, are reserved to the states or to the people of the states. So we have a what's called a system of dual sovereignty. The states have their powers, generally referred to as police powers. These police powers include the power to protect the health, safety, and general welfare of the people who reside in the states, in that particular state. And then you have the Congress and the federal government, and they have those powers that are specifically given to them by the Constitution. So the general idea, at least in theory, is that the federal or central government needs to have limited powers, those powers that are given to it or conferred to it by the Constitution, and the states have this general residual power. Sometimes these powers can overlap. Sometimes you have both the states and the federal government regulating in the same area. Other times you have the states taking the lead, or in the alternative, sometimes you have the federal government preempting the states and the federal government regulating exclusively. That will vary upon the subject matter. For our particular purposes, I just want to introduce you to that fundamental idea of sources of law, that there are really two important sources of law: federal law and state law. In my next video lecture, I want to talk about the difference between civil liability and criminal liability. Thank you so much for your attention. Have a good day.